How do you prove you can't do any other work in order to win your Social Security disability claim? Hi, I'm Mark Whitehead, a board-certified Social Security disability attorney. To be declared disabled, a claimant's impairments must prevent him from doing any other work. This is the fifth step in the five-step sequential evaluation process used by the Social Security Administration. If the claimant can't do any other work done in the past because of the claimant's severe impairments, the Social Security Administration will consider the claimant's residual functional capacity, his age, his education, and his past work experience to see if the claimant can do any other work. If the claimant cannot, the Social Security Administration will find him disabled. While the claimant bears the burden of proof at the first four steps of the sequential evaluation process, at the fifth step, the burden shifts to the Social Security Administration to show that the claimant can perform other work. At step 5, you have to prove nothing. Unlike all the other steps where you have the burden of proof, at step 5, the Social Security Administration must prove that there are other jobs out there that you can do. But don't get too happy, because the Social Security Administration is very good at finding vocational experts that are very good at finding jobs that you can do. It's at this point where an experienced attorney is needed to cross-examine the vocational expert. To determine whether someone can't do any other work in the regional or national economy, the Social Security Administration will look to what's known as the medical vocational rules to establish disability based on a physical as opposed to a mental disability. These rules are commonly referred to as the grid rules because they are physically laid out in a grid. To apply the grid rules, the Social Security Administration will make a finding of fact as to the claimant's RFC, their age, their education, and their previous work experience. Assuming the claimant does not have a mental or emotional impairment, then the grid rules will direct the Social Security Administration in making a determination of disability. The regulations provide that older age is an increasingly negative vocational factor for persons with severe impairments. In other words, the Social Security Administration recognizes that as someone gets older, it becomes more difficult to both overcome severe impairments and to adapt to the workplace with such impairments. In short, the standard to be found disabled by the Social Security Administration gets easier as you get older. The key ages when applying the grid rules are at age 45, 50, 55, and 60. However, the regulations also provide that age categories are not to be applied mechanically in borderline situations. This topic is discussed more in Chapter 14 of my free ebook, The Social Security Disability Puzzle. Visit www.disabilitydenials.com for a free downloadable copy or call 1-800-562-9830 to discuss your particular Social Security disability issue. I'm Mark Whitehead. Thanks for watching.